Rahul Shivshankar, my colleague, also joining us for more perspective on this. The Places of Worship Act was something that was used as grounds by the Muslim side so far to contest every single decision that has been coming in from different courts of the country, Rahul, as far as the right to pray in the Gyanvapi Mosque premises is concerned. Are we expecting that to happen yet again?
Poonam, obviously the Muslim side is not going to be extremely happy. Let's go first across to Vishnujain Jain, who will explain the legal intricacies.
बोर्ड के द्वारा नाम निश्चित पुजारी से पूजा राजभोग तहखाने में स्थित मूर्तियों का कराएं और इस उद्देश्य से 7 दिन के भीतर लोहे की बाड़ आदि में उचित प्रबंध करें। ये कोर्ट का ऑर्डर है कि 7 दिन के अंदर उस बैरिकेडिंग में उचित प्रबंध करके काशी विश्वनाथ ट्रस्ट बोर्ड वहाँ पे पूजा पाठ स्टार्ट करेगा।
ये काशी विश्वनाथ का जो मंदिर की ओर से जो पुजारी होंगे वो वहाँ जी बिल्कुल पाठक जिनकी ओर से बात तक वो भी
जा सकते हैं और काशी विश्वनाथ ट्रस्ट भी जा सकते हैं,
कोई भी जा सकता है
और सारे भक्त लोग भी जाएंगे।
तो सारे भक्त लोग भी जाएंगे और वहाँ पर पूजा पाठ के लिए, चूंकि काशी विश्वनाथ मंदिर जो ट्रस्ट है यानी कि जो काशी विश्वनाथ मंदिर है उससे जुड़ा हुआ जो प्रशासन है वो वहाँ पर एक पुजारी नियुक्त करेंगे और उस पुजारी को
getting us more details of what exactly transpired in court. Going back to Rahul Shivshankar, who was getting us more perspective on this. Over to you, Rahul.
There are a couple of points that one should make in the immediacy here. One, that we should eschew triumphalism. This is a matter that, as you just heard some lawyers, dates back to about 31 years, Poonam. This was a part of lived history. And I want to go across to Shankar Jain ji to get more perspective. Shankar Jain ji, धन्यवाद, आप हमसे बात करेंगे अब 2-3 मिनट के लिए. ये Vishnu Jain is also there with us. Mr. Vishnu Jain also there with us. Both Shankar Jain and Vishnu Jain have been leading this particular fight to win back rights of Hindu devotees. Vishnu ji, Hari ji, can you please put this into context for us? आज हुआ क्या है?
Before the District Court of Varanasi, wherein we had asked that in November 1993, in the Vyas Tekhana, there was daily puja and archana which was going on. A state government misusing its powers without any written orders stopped that puja in November 1993. And today that illegal act of a state government has been rectified by the Honorable Court. The Honorable District Court of Varanasi has directed the District Magistrate Varanasi to start puja and daily puja within 7 days by making appropriate arrangements with the iron fencing. So I see this order on the similar footing which was passed by Justice K.M. Pandey on 1st February 1986 in Ram Mandir case, and it will be the first time in 30 years that we are going to enter the so-called disputed premises and start puja path.
Vishnu ji, 31 years later, the right to worship there has been won back by you. Why was this right to worship first stopped? Why was a lock put on the Tehkhana?
Without any written orders, Rahul, I want to say with lot of sense of authority that there is no written order of the state government to stop this puja and worship which was happening after the enactment of Places of Worship Act, and in violation of Section 3 of the Places of Worship Act. This puja part was stopped, and today that puja part has been restored by the District Court of Varanasi. So it's a very major development in Gyanvapi case.
There are many witnesses, Vishnu ji, many witnesses that have actually testified to the fact that the Vyas family had been conducting uninterrupted puja for decades altogether at this place.
Yes, you are absolutely right. There are a lot of witnesses who have given this testimony that in that premises in question, puja part was going on, and today the illegal act which was conducted by a state government in November 1993 must be restored, was a demand which has been allowed by the District Court.
Vishnu ji, you have equated this momentous decision today to what had happened in 86 in regards to the Ayodhya Ram Mandir case. Can you elaborate on that?
In Ayodhya Ram Mandir case, the Justice K.M. Pandey, the District Judge of Varanasi, for the first time on 1st February 1986, ordered for opening of locks. So today I see this same order on the same footing in Gyanvapi case.
Vishnu ji, the other side constantly invokes the Places of Worship Act.
The Places of Worship Act applies in our favor. In violation of Section 3, Rahul, our puja part was stopped. Places of Worship Act was enacted in July 1991, and Section 3 gave a mandate that Places of Worship Act should not be violated. In violation of Places of Worship Act, the state government had stopped that puja part.
Vishnuji, what happens next?
Now we are going to approach the district administration for immediate compliance of this order, and I would request the state government to immediately comply with the order of the district magistrate.
There was a development also today where the Muslim side has been issued a notice. Okay, I think we might have lost Vishnu Shankar Jain there. Poonam, just to give you a bit of a sense of what has actually transpired, Vishnu Shankar Jain is right, of course, when he invokes rhetorically that this moment is similar to the one that dates back to 1986 when the Ayodhya DM there passed orders to unlock the premises to allow the Hindu side to offer prayers. So there is a parallel. Of course, the two cases are very different. Here there is material evidence, historical evidence to suggest that there was a temple fully functional and it has been obviously committed to lived history, and that temple was destroyed on the instructions, specific instructions of Aurangzeb. In the Ayodhya matter, while there were, of course, historical truths, the one area where there was an ambiguity was whether the temple that was destroyed at the same time to construct a mosque. So that is something that was not very well clarified by the ASI. The ASI said that, look, a temple was destroyed. Whether it was the Ram temple at that very moment that was destroyed to build the Babri Masjid is still not clear. And that's one of the things that, of course, the Muslim side in this particular case has also invoked. And of course, in the overarching Ayodhya verdict has also invoked. We must eschew triumphalism, of course. There will be celebrations in the Gyanvapi, in Kashi today. And of course, the right to restore puja, etc. will perhaps be committed in a week or so. But Poonam, the fundamental fact about... Now, let me take you through Section 3 of the Place of Worship Act. This is rather important. It says nothing contained in subsection 1 and subsection 2 shall apply to any place of worship referred to in the said subsection which is an ancient and historical monument or an archaeological site or remains covered by the Ancient Monuments and Archaeological Sites and Remains Act of 1958. What does this mean? That anything that is over 100 years old, any particular installation, place of worship, more than 100 years old, is exempted from the Place of Worship Act. So a large number of lawyers and stakeholders in this particular case are arguing that the Gyanvapi Mosque complex, being deemed much older than 100 years, there is enough historical evidence as well as now an ASI report to suggest this, will be exempted from the Place of Worship Act of 1991. So this is really a point that is constantly brought up legally.